Now, these laws, as we all know, have come into force since 1st of July 2024. So max to max, it's been 6 to 7 months that these laws are implemented. So it is not that we are having case laws or judicial pronouncements from the Honorable Apex Court, from the Honorable High Court, so far as new laws are concerned. So the time will tell us as to what are the interpretations of newly promulgated provisions or newly legislated provisions. So we'll have to wait for some time. But for now, we are going to have literal interpretation or the contextual interpretation in the context of preamble and all. So one more thing I like to, because while I like to tell that while discussing with the honorable principal ma'am, I was, I mean, I was saying that I mean there is paucity of time because we are having hardly 1.5 hours with us. So within 1.5 hours we can justify half hour for each of the new legislation. So within half an hour, it will be difficult for me to tell all the provisions in literal sense. So I'll be kind of brief and elaborating the concepts as such, not by section, because we are having paucity of time also. So these laws are there. I have shared my PPT or a note kind of thing to Honorable Principal Ma'am. You can take it from her. So no need to write down anything. We are having new Bear Acts, I suppose, with you. So starting with the BNSS, which I like to start with. So Bharatiya Nagrik Suraksha Sanhita. Now, at the outset, what we see is the change in the name. Earlier, it was Criminal Procedure Code. Something criminal was at focus. Now we are having Bharatiya Nagrik Suraksha Sanhita. That is, Nagrik is at focal point, and Suraksha of Nagrik, meaning thereby protection of the citizens, is the focal point of new laws, rather new CRPC. Because ultimately, and one more thing is bound to happen, we are aware about the old sections. Now we are having altogether new number of sections. So like 154 FII was there. Similarly, 173 charge sheet was there. Similarly, section 200 verification was there in CRPC regime. So including myself, nobody is thoroughly acquainted or comfortable with new sections. So we'll not focus on sections. We'll focus on new concepts rather. So this is also going to be an important aspect. So let us start with the Bharatiya Nagrik Suraksha Sanhita, and this section, Bharatiya Nagrik Suraksha Sanhita, is basically the new CRPC, we may say. So I'll be a bit fast in it. As all we know that it received the assent of President of India and it was promulgated later on. So the aim and object is to consolidate and amend the law relating to criminal procedure. Precisely same aim and object was there of CRPC. So virtually there is no change in the aim and object of CRPC and aim and object of the BNSS, Bharatiya Nagrik Suraksha Sanhita. So same aim and object. So far as old laws and new laws are concerned, we are talking of BNSS. Now the short title was the Bharatiya Nagrik Suraksha Sanhita. As I have already told, that Nagrik Suraksha is the focal point of the new law. So we have to appreciate that fact also. Similarly, so far as Bharatiya Nagrik Suraksha Sanhita is concerned, why I am repeating this name again and again, because we should be conversant with this name. Because I was comfortable, or we were comfortable with Criminal Procedure Code. Now we have to utter this name time and again, because if we are acquainted, or if we are conversant with this new name, that will be a bit helpful to all we people to appreciate the new law. So Bharatiya Nagrik Suraksha Sanhita, it came into force on 1st of July 2024. This we know. So this was the one more thing. Now we are going to see what is basically structural change. What is the structural change so far as CRPC is concerned, and what is structural change so far as BNSS is concerned. Earlier in CRPC there were 38 chapters. Now we are having 39 chapters. One chapter added. One more thing. Earlier in CRPC there were 484 sections. Now we are having 531 sections. So sections are increased. Don't worry, because earlier also these number of sections were there in CRPC, but under the caption of some amendments and all. So those are now linearly numbered. Now earlier in CRPC there were 484 sections. Now we're having 531 sections. So this is new change. Now so far as schedules are concerned, there is absolutely no change. Earlier in CRPC there were 2 schedules. Similarly in BNSS there are 2 schedules. So some new definitions are introduced. as I have already told, that some scientific advancement which were not there, which have been witnessed by our generation in 21st century, were not there in 19th century. So when 1898 CRPC was legislated, which was kind of revisited in 1973, had no scientific advancement. In recent years, we are having mobiles with us, laptops with us, we are having even cloud memory, storage memory, different kind of documents, clips, and all and all. So cognizance thereof was required to be taken by the new law. For that purpose, some new definitions were required to be incorporated in CRPC rather in new BNSS. Now, what are those definitions? Now, first definition is the audio video electronic means. Now, this is very important important definition. But now, if we minutely peruse this definition, we find a bulky definition has been there, audio video electronic means. But just to have conceptual idea as to what is audio video electronic means, we should keep our mobile phone in our mind. Now, if we are having mobile phone with us, so that is basically a means. Now, say for example, this is the mobile phone. Now I have this means sadhana. Means म्हणजे असं नाही. It is means it is a sadhan. It is means, and this can be used for various purposes under the BNSS. Now, audio video electronic means, if we keep our mobile phone in our mind, we can appreciate that definition properly. That definition is bulky, which I'll flash within a second. Now, the term bail, which was not defined. Similarly, bail bond was not defined. Bond was not defined. Now, these are the three definitions which we are using. We are using these definitions since 1898, since 1973, but these were not defined anyway. So those were not defined anyway. Now we are having these definitions with us. Now, even Britishers who drafted this law, or who legislated this law, did not provide for definition of bail, definition of bail bond, and definition of bond. Now, these definitions are for the first time floated in BNSS. And last, electronic communication. So whatever we are having, whatever myself, BM Patil, is having communication with all these 83 persons, is the electronic communication. I am actually not present physically before you, but I am having some kind of communication with all we people, and this is electronic communication. So even if a mobile phone, by using mobile phone, I am sending a kind of video clip, I am sending audio clip, I am sending text message, I am sending MMS, I am sending SMS. All this communication is electronic communication. Now, by going through the definition, particularly of audio video electronic means and electronic communication, we are having these concepts with us, which are been defined with some bulk kind of words. And these definitions are, huge definitions. But to conceptually understand those definitions, we should know what is mobile. Now, if we know what is mobile, we know what is audio video electronic means. Now, if we know sending one text to another, sending text by one person to another person, we know what is electronic communication. So these 5 definitions are newly floated. Now, bail bond, and bond, I hope there is no need to elaborate on these topics, because we are dealing with that. Bail bond, and bond from last many years rather. So this is important. 5 definitions are newly introduced. Now it is up to the honorable law colleges to teach these definitions, and honorable students to to have memorize these definitions. Particularly, believe me, audio video electronic means and electronic communication. Thank you, because I thank myself because I have passed out now. But memorizing these 2 definitions is kind of a task now. So audio video, these 2 definitions are really bulky. It is for you to memorize, but keeping in mind the concepts, you can understand it in proper science. Now, the definition I will flash just for your information. This is the definition of audio video electronic means, particularly the focal point are video conferencing, identification, search, seizure, evidence transmission, and purposation means. Now this you can appreciate, you can memorize. So this is also important. Similarly, that term bail has been defined in section 2(1)(b). So now see, it is very easy to understand where the bail is defined. Bail for B for bail. So this you can understand, that release of a person from accused or suspected of commission of offense from the custody of law upon certain conditions imposed on execution by such person, a bond or bail bond, that is bail. Jamin in Marathi we may call it. So this is bail. One more, bail bond, personal bond and bail. we know 21D. Similarly, bond, section 21E, that is PR bond. Generally in courts it has been called. So these are the concepts which are newly defined rather. Now the last, the definition of electronic communication. Now, if we go through this electronic communication, just keep in mind that whatever conversation that has been going on between myself and you people is electronic communication. If I am talking with my friend on mobile phone, that is electronic communication. If I am sending one SMS to my friend, that is electronic communication. If I am sending one kind of audio, video, something by my mobile phone, maybe WhatsApp, maybe Instagram and all, that is electronic communication. So communication involving electronic gadgets is electronic communication. So is the simple concept. Now let us see how it has been defined. Now it has been said communication of any written, verbal or pictorial information or video content transmitted or transferred, whether from one person to another, or from one device to another, or from person to device, or from device to person, by means of electronic device, including telephone, mobile phone, or other wireless communication device, or computer, or audio video player, or camera, or any other electronic device or electronic form, as may be specified by notification in the notification by the central government. Now, what do you understand by this? I'll take something in Marathi. ज्याला आपण मोबाईल फोनवरून एका माणसाने दुसऱ्या माणसाला केलेला जो मेसेज असेल त्याला इलेक्ट्रॉनिक कम्युनिकेशन म्हणायचं. मात्र एवढी मोठी डेफिनेशन वाचल्यानंतर आपल्याला काय आठवतं? कहना क्या चाहते हो? So is the simple. So electronic communication is been defined by using very many words to cover everything so far as electronic communication is concerned. But conceptually, electronic communication means communication involving electronic gadget. Sent from one device to another device, one person to another person, or device to person or person to device. So this is the new definition which has been floated. I mean, it is up to you how to memorize it. So in law college, in your law examination, you will be required to write it down if it is for the short note or long question. So this is that. Now, some provisions which were there in CRPC now are deleted or repealed or omitted from BNSS. Now, what are those provisions which were in CRPC, but now those are not in BNSS? Now, the first thing is that definitions are deleted. So first thing is that of the India. Now the definition of India was there in CRPC in section 2F. Now BNSS does not include this definition. Now India is not required to be defined because we being the Indians, we should know what is India. Some third person coming by law should not tell me as to what is India because I know what is India being Indian. So there should be no formal definition. So the term India has been deleted. Similarly, metropolitan area, which was there in section 2K of CRPC, that has been omitted from BNSS. Now, every city, every town, every village, every person are brought on equal pedestal. So Satara is having same qualification as that of the Mumbai. Earlier, Mumbai was metropolitan city and having different kinds of courts, metropolitan magistrate, and chief metropolitan magistrates and all. Now, every officer, rather every judge, every court in all over India will be the same. Now, there will be no different treatment for metropolitan area and all. So, even Mumbai, Calcutta, which were the metropolitan cities, now those will be at par with all the cities. So, the legal system in that particular city or that particular town or that particular area will be the same as that of the other area in India. So, that has been removed. Now, concept of pleader has been removed, prescribed is removed. Similarly, metropolitan areas was having some different treatment in CRPC under section 8. Now that is no more. The important thing is that now there will be no assistant session judges. Earlier there was when I was firstly promoted, I was assistant session judge, meaning thereby I can impose the sentence up to 10 years only. Impose the imprisonment up to 10 years. Now, there will be no assistant session judge. Every session judge will be additional session judge or session judge, but no additional session judge, no assistant session judge. So the office or the court of assistant session judge, rather, the post of assistant session judge has been omitted, deleted, repealed. Now, henceforth, you will not come to know, you will not get any assistant session judge in India. So this is important. Now the courts of metropolitan magistrates are also been removed. Chief metropolitan magistrate are also been removed. Now there are some novel propositions floated or new laws have been brought into effect in BNSS. Now, what are those novel propositions in BNSS? Now, the first thing is that limit of fine by the magistrate. How much I mean, it was 10,000 and 10,000 and 3 years. Now 10,000 now 10,000 is been modified in BNSS. Now magistrate can impose fine up to 50,000. So, actually speaking, in Maharashtra, this 50,000 was already there. But so far as India is concerned, now all the magistrates, all the judicial magistrate first class in all over India can impose fine up to rupees 50,000. Earlier it was 10,000, but so far as Maharashtra being progressive state, it was there in 50. It was there up to 50,000. So virtually speaking, for Maharashtra, now this is the greatest change that has been brought into effect in BNS. Now the new concept has been floated, that is community service. Now, say we all know as to reformative theory of punishment, that we are there not to kill the sinner, but to kill the sin. All we people must be aware as to reformative theory of punishment. Now that has practically been implemented, accepted, and enacted by way of community service. Now, if a magistrate can impose the sentence of community service, now community service has been defined in section 23. Now, this is articulation of reformative theory of punishment in BNSS. Now, that does say that community service means the service which would benefit the community, and the accused shall not be entitled to any remuneration. Now, say for example, an accused is convicted for offense punishable under section 353. So the community service may be imposed that this person, that accused, instead of putting behind bars, he can be directed to render some services. Now, say for example, if he has committed theft, so he may be directed to serve the society in a particular form, and he will not be entitled to any kind of remuneration. So that is important. So community service is new service implemented in BNSS. So it is altogether new definition that has been floated. So this is there. Now, consecutive running of sentences. This is not much important. Second thing is now arrest. Now, there were some offences for which punishment was less than 3 years. And if an accused is subjected to arrest, he used to suffer like anything. Now, say for example, I am being arrested, I being an accused, if I am arrested for an offence punishable with imprisonment up to 2 years, and if I am detained behind bars, the very purpose of arrest would be subject me to pre-trial incarceration, and that will be injustice for me. So flimsy kind of offences were there, which were requiring, which used to be effect arrest, in which accused used to be arrested. Now, by virtue of section 35(7), it is not that in all cases accused will be subjected to arrest. Now, if the offence is punishable for imprisonment less than 3 years, and the person is either infirm or above 60 years of age, then in that matter, that accused cannot be arrested as a routine or in casual manner. Now, if such an accused is to be arrested, prior permission of Deputy Superintendent of Police would be required. Otherwise, that arrest will be illegal arrest. That arrest will be, subject of illegal detention. So, police machinery now cannot arrest the person if he is imputed to have committed an offence punishable less than 3 years, and the person is above 60 years of age. So then in that matter, that accused cannot be subjected to arrest. So this is important. Now, for that purpose, prior permission of the officer below the rank of DYSP, not officer above the rank of DYSP, not arrested without prior permission. So that is important. So every time now there cannot be mechanical arrest in flimsy offences. That is important. Now this concept is newly floated in CRPC. Now it used to happen that if an accused is arrested, he used to be put behind bars at a particular lockup. Now relatives of the detainee or relatives of the person who is detained were quite helpless as to where to trace him out, where to get his whereabouts, because police machinery may or may not tell as to where that accused person has been kept. Then in that matter, the persons used to be quite helpless as to, I don't know where my brother has been kept. I don't know where my relatives who is arrested is been kept. So then in that matter, a new office has been created in BNSS. As has been rightly said that here under this law, we are looking after the Nagarik Suraksha. So we have to see as to Nagarik Suraksha, because if the person is arrested, a police officer is made, rather the police officer is, post of police officer has been created, who will be responsible to maintain the information in respect of the arrest. Now say for example, X is the person and he is arrested by Satara police station. His relatives should know as to where he is been kept, because police may or may not tell. Then in that matter, the person, a post of DPO has been created, that is designated police officer. He would be above the rank of ASI, Assistant Sub Inspector, and he will maintain all the information in respect of arrest. Now it does say, section 37 does say that state government to designate a police officer. Now why this post is important? Because if my relatives, or if my some near and dear one has been arrested by police, I should know where it's been kept. So to whom I should approach? I should naturally approach to DPO, that is designated police officer. And this post has been created to give the information as to where that accused has been where that arrested person has been kept. He will keep all the information. So one needs to go to that DPO or designated police officer who would be not below the rank of ASI to tell as to where that arrested person has been detained. So this is important fact so far as Suraksha is concerned. So this is important. Name of such person, rather name of such officer, will be prominently displayed at the police station. And this is important provision, because one should know as to where the arrested person is been kept, so that his provisions regarding his bail and legal advice can be made. Now, why this is important? This is in tune with the Article 21, which deals with the right to life and personal liberty. So there comes the personal liberty. This is important aspect. Now, next thing is handcuffing. As all we people know, that what we know about the arrest is that police officer coming and putting handcuffs and making his parade all over, because in rural areas it has been said that the person is handcuffed. Handcuffing means beda lavne. Okay. No, so while effecting arrest, police rampantly used to handcuff the person and take him throughout. So handcuffing is kind of unnecessary restraint, because the person is subjecting to the custody of police. He need not be handcuffed. If I am saying that yes, I am ready to come with you, my personal liberty, I am ready to surrender it before you, there is no need that I should be handcuffed, because it is kind of humiliating thing. My human rights are going to be hampered first of all. So it is henceforth there will not be handcuffing as it is. So there will be no handcuffing as it is in all the cases. So what are the instances when there can be handcuffing? So it has to be in grave offenses only. Police has to consider the gravity of offenses. Some instances are being quoted in section 43(3). It does say that if he should be habitual offender, repeated offender who has escaped from lawful custody, or offenses of organized crime, terrorist act, drug related crime, illegal possession of arms and ammunition, murder, rape, acid attack, counterfeit coin, human trafficking, sexual offenses against children, offenses against state. Now these are the certain instances wherein police can legitimately use handcuffs. Barring this, unless the offense is grave, there cannot be handcuffing. Now say I have committed theft of 200 rupees, whether it can be handcuffed. Say for example, there is plain voluntarily causing hurt offense 323 or 324 maybe. Whether he can be handcuffed, and absolutely no. So we have to keep in mind section 35 as well as section 43(3). Now these are the novel glimpses of new law, which speaks of suraksha of the person. So in these premises, everybody cannot be handcuffed. Rather, everybody cannot be arrested first of all, and even after arrest, he cannot be handcuffed, because qualified version has been given in section 43(3). This we have to appreciate. So this is important aspect of the new law. Now if a person is physically disabled or mentally disabled, then his identification parade need not be conducted in jail premises or any other premises. It can be even conducted by videography or even by way of use of mobile. Now here comes the audio, video, electronic means which we which we saw defined in section 2. So even test identification parade who is of the person who is mentally or physically disabled can be conducted by using mobile phone. So earlier there was provision of videography. Now videography and video cameras, huge cameras is not the scene of the day. Now it can, by using mobile phone also there can be recording. So that can be used, or that can be made, or test identification parade can now be used, can be made by using of mobile phone. So this is important provision which has been newly promulgated or newly legislated. Now electronic summons, all we know as to what is summons and electronic summons and all. So all we people know that kind of summons that it used to be in duplicate under section 62 of the CRPC and all. So now there can be electronic summons. Now how that electronic summons will be? That summons will be electronic or in encrypted form. Now if at all summons is to be served in Gadchiroli by the court at Satara, an electronic summons by click of mouse can be sent. It is not necessary that police person should take that physical summons, carry it to Gadchiroli by traveling for 2 days and serve it to the person at Gadchiroli. Not necessarily. Even a person who is sitting at Ludhiana can be served with electronic summons in a fraction of seconds. So we are having some kind of global village now. So physical summons, paper summons is about to be dispensed with, believe me, in few years, forthcoming few years. In forthcoming few years, we will see as to the electronic summons being sent by way of electronic format. That will be in encrypted format. We all know as to what is encrypted format, because all we are using WhatsApp now. So every message in CRPC, every message in every message in WhatsApp is in encrypted form. I mean, there can be end-to-end visibility. Nobody can tamper in between. So that summons will be somewhat like encrypted format of summons, and it will bear the seal of court and digital signature. Now, believe me, all we officers, judicial officers, as well as our judicial staff also is having digital signatures with us. Now the judgments which have been uploaded on Supreme Court website and High Court website, as well as even District Court website, are always bearing digital signature. So digital signature has enrolled or has been floated even in our system also. So now henceforth there will be electronic summons, which is quite salutary feature which has been floated. So this is important. One more thing. Now how it is to be served? Now if digital summons is there, it has to be served electronically by way of electronic communication. Now that summons will be served by way of electronic communication, and for that purpose we should know what is electronic communication. Electronic communication means by sending of some electronic gadgets. As we know that WhatsApp is there, Instagram is. I mean, these are not legally recognized modes of summons, modes of electronic communication. But in near future, we'll come to know as to what are the modes or softwares to be used for electronic communication. So summons can now be served by electronic communication, as the state government may provide by rules. Now rules are awaited. Now by using those rules, we can effect service of summons for upon the accused or witnesses by way of electronic communication. Believe me, what is the practical problem before every court right now is the summons service. Now if summons is to be served, as we know, it takes a lot of time. Now if we know, if that can be served by electronic communication, our valuable time of the courts and ordinary citizen will be preserved. I mean, that can be saved. So summons can now be served by way of electronic communication. This is important now by using those rules, because we are having a video conferencing rules with us. But regarding summon service, I mean, the rules, if they are implemented, we can serve it by way of electronic communication. Important. And for that purpose, we are required to maintain register. Now see, if at all I want to institute one suit in civil court, I'll be required to give my address, email address, and phone number. Now somebody may say that, sir, I'm having phone number, but I don't have email address. Now believe me, every person who is using smartphone is having email ID. All we know. So that you have to give. Because phone numbers and email addresses are necessary nowadays. So that e-linking and all, because I hope there will be hardly 1% people who don't know about this email and electronic media. So now that at police station level and at the court level, wherever, because the person who is in legal difficulty, either he will go to police station or he will go to the court. Now at the door only he will be asked as to what is your email address and what is your phone number, because he'll be required to he will be required to be communicated or served with summons or other processes of the court by way of electronic communication. For that purpose, email address and phone numbers are necessary, and that will be taken at the level of our registrars. That will be taken at the level of police stations in the local police station. So this is important. So summons issue, which really takes a lot of time, it's been taken care of by the new law. So this is important. And see, because this was the provision which was really required to be incorporated in law. And here comes why new law. Because 1898 code, which was first law commission code of CRPC and later on revisited in 1973. In 1973, there was no email, there was no phone, there was no, I mean, we can understand, we can appreciate the situation as to how it was there in 1973. Now in 2023, we are having rampant changes. And why not to take cognizance of it? So, and why not to make use of it? Because even post department is, I mean, using electronic communication and all. Now Telegram is no more, because the new generation may be knowing Telegram as an app. Our generation is knowing Telegram as that cut, and that Telegram tar we used to say. Now Telegram is no more. Even post department has changed. So even after this, we are required to change. So summons can be now served with electronic communication. This is greatest boon, I'll tell you. This is, I mean, like Ashirwad to our legal system. We can effect, and for maximum time of a litigation is being taken in summons service. So that is that will be no more. Now see, we right now today we don't have any modality to implement, but in the run of time in next few years, I'm quite optimistic that this will be implemented even at taluka level. Taluka courts will be, and those are provided with infrastructures now, but minor training and all issues are there. So summons that has been taken. Now summons, how it is to be served? All summons can be served by electronic communication shall be considered as duly served. Now one cannot say that, sir, though you have sent it by email, I have not received paper summons. Now I cannot take that defense. Why? Because electronic communication service is considered as valid service henceforth. So believe me, henceforth your mobile phones have to be active all the times, particularly those which are given by you in the courts and police station. Now you cannot say that, no sir, I have not, because I have not opened it. That blue tick is not there and all, because Indians are known for many things. But now there is presumption, or rather there is a stipulation made that even that the summons which has been served by electronic communication shall be considered as duly served. So legal recognition has been given by way of section 70. This is important aspect. One more thing. Next is that recording of search and seizure. Now all we people know that if police effects raid, there will be video shooting. Now if police, because if you are having some knowledge about this court procedure, that prohibition cases and seizure of liquor, seizure of some gambling articles, now those acquittals will not be there, because police machinery is going to mandatorily record every raid, every search, every seizure will be recorded by police department henceforth. And that will be, I mean, increase the conviction ratio and imprisonment ratio. So there will be use of this new electronic means or audio video electronic means while effecting search and seizure. So process of search, process of conducting search, taking possession, preparation of list of all seized things, signing of list by witnesses, and now these things will be necessarily mandatorily recorded by audio video electronic means, preferably by mobile phone. Now henceforth police will be coming with mobile phone. He will have a mobile phone with him and he will record everything. Now believe me, if I am traveling from Powai Naka to Rajwada, and if constable stops me, the first thing what he does, he starts his mobile phone and he starts recording your behavior. He will start recording my behavior as to how arrogantly I am, whether I am tendering my license, whether I am tendering my documents, whether I am tendering my insurance policy and all. They get it recorded everywhere because that is going to be used as evidence against me. So because this is important, and this is the proper articulation of audio video electronic means in the new law. Now that is given legal recognition under section 105 of the BNSS. So this is going to be important aspect. So believe me, 100 section, and I'll request on all the honorable principals and all the honorable faculties to imbibe this section on every student. Section 105 is going to be the greatest section henceforth in CRPC, because our every conduct is going to be recorded by police, particularly in respect of search, seizure and raids, because there will be no way out if my conduct is been recorded while search and seizure in the mobile phone or by using of electronic means. So if I am being captured by police in audio video recording, I'll have no defense. Now, gone are the days when there used to be lengthy cross examinations and all and all. Now, henceforth, we have to keep in mind that now courts will be rather the investigation machinery first of all, and later on the courts will be more articulated with electronic evidence. So this is important aspect, and this is really the salutary feature in the new law. So, and if a particular thing while seizing and while taking possession, if it has been searched, if it has been possessed, if it is while searching, while taking possession and while seizing the things, if that is been recorded by police will not keep the recording with themselves. They will send immediately to the nearest magistrate. So that recording will immediately be the part of record of the court. Later on, charge sheet may be filed. And what will be the fact of the case, that will be decided later on. But immediately after recording the search and seizure, police are required to send that recording, which is preferably done on mobile phone, to the nearest magistrate, maybe the district magistrate, sub-district magistrate, sub-divisional magistrate, or JMFC, judicial magistrate first class. Now we are receiving the recording, and we are keeping the record of it. Courts are keeping record of it. So there will be less scope for sparing the real culprit. So this is important aspect. Next is this is new provision under section 107. Now that is attachment, forfeiture or restoration of property. Say for example, I have committed fraud on a particular place. I have committed defalcation. I have committed misappropriation, and I have earned huge amount. And I have earned huge property with me. That property will be first of all proceeded against. Now, section 107 is the greatest. I mean, it is bulky section. You can go through that section, but the spirit is that the crime proceeds which the accused gains, or the property which accused gains by using by way of commission of offense, that property will be seized first. That property will be proceeded further. That property will be sold, and crime proceeds, or the money which will be received out of that crime proceeds, will be distributed among the affected person, rather the victims, we may say. This is the important salutary provision. So that is there. The investigating officer can, with approval of SP, apply to the court and magistrate to attach the property and obtained from or derived out of crime. So this is important provision. Now there is this section is, I mean, bit bulky section, which and minute provision has been laid down. 107 will be the long question, if I mistake not, in your examinations, and new provision is there. So 107, please go through it. This is important provision. Now one more thing, attachment 107 is, I mean, it is legislated in detail by Bharatiya Nagrik Suraksha Sanhita. So you can go through it. Procedure has been given, detailed procedure, because owing to paucity of the time, I may not be in a position to tell all this thing. Now, next thing is that forensic assistance. Now this is quite new provision that has been laid down. Now, what used to be happened, because say for example, a murder has been committed at Rajwada, or at Rajwada area. Say for example, at Devi Chowk there is a murder. Now that was a murder committed by stabbing. Now the blood was lying on the road. Now somebody reported it to city police station, Satara city police station. Now police FIR was registered. Police immediately went to the spot. Now police person who is going to the spot, who is seeing or who is watching or who has observed that blood stain is lying on the road, and that blood stain is of the deceased. Now that blood stain is required to be seized from the spot, or that is required to be taken on cotton swab and seal it and send it to the forensic laboratory during the investigation. Now it used to happen that, say for example, our officer is like head constable is there, ASI is there, PSI is there. Now these police persons are not experts in collecting cotton swab of blood or blood sample of by way of cotton swab. They are not expert person. Now for that purpose, for taking the blood stains lying on the spot, some expert is required to be employed at that spot. Now it used to happen that police used to take some kind of that scrapping, some kind of blood sample from the spot, some soil, earth mixed, some soil used to be taken, some blood stain and soil used to be taken from the spot. They used to keep it, and they are using it to keep it in some plastic box, polythene bag, or some kind of containers, and those used to be sent to the forensic science laboratory. Now forensic science laboratory upon analysis used to communicate to the court, sir, the sample is not been properly collected, so we are unable to state as to what is the blood group, or we are unable to state whether it is a blood group, whether it is a blood of the deceased or the person who has been murdered. The only fault was that of the investigation machinery. They were not armed with some kind of experts while collecting that while collecting those samples, because they were not armed with those experts team. Now BNSS has incorporated a new concept called as forensic assistance. Now it does say that if the offense is punishable of more than 7 years, then forensic team will go to the spot, and officer in charge of the police station, say for example Rajwada police station or city police station, they will depute forensic assistance to the spot, and they immediately will collect the forensic evidence available on the spot, maybe blood stains, maybe semen, maybe other biological sample, or any other sample which is there on the spot. And upon collection of that spot, there can be proper analysis of the guilt of the accused. Many a times defense has been taken, sir, this is not the blood stain of the accused, this is not the blood stain of the deceased, this is not the semen of the accused. Why? Because there is no proper collection and proper results are not coming from the respective laboratory. And that is why forensic assistance is necessary, and that has been articulated or implemented in now new BNSS. So this is important. So now there will be no coming out of clutches of the law merely because there is no forensic evidence. Why? Because forensic evidence will be properly collected under the new law. For that purpose, officer in charge of police station, upon receipt of an information in respect of cognizable offence, is required to take or depute forensic assistance on the spot immediately. So it does say that if offence is punishable with imprisonment of 7 years or more, then forensic expert to visit the crime scene, the spot of incident. What is the purpose? To collect the forensic evidence and to collect the video, and that particular process will be videographed, maybe on mobile phone or electronic communication or any other electronic gadget or device. So see how proactive we are in BNSS while implementing, while articulating forensic assistance, or while articulating the electronic modes. Now there will be videography. Now there will be recording of collection of blood sample from the spot. Now this was not there in CRPC, and on that count alone, accused used to be acquitted because there used to be benefit of doubt. Now, sir, there is no blood sample properly collected. Used to be the defense. Now, sir, the impressions which are received from, or the CA report, chemical analysis report, which we used to receive from forensic laboratory, used to show that, used to depict that, sir, there is no conclusive proof regarding blood stains. On these minor grounds, there used to be acquittals. Now there will be no acquittal merely because forensic evidence is not properly articulated. Why? Because that team will be going on the spot. That team will be deputed on the spot immediately by the officer in charge of police station, and that is how this is going to bring or book the offender and to do the justice. So this is fantastic. I mean, it's great. And believe me, these teams are being I mean, so far as state of Maharashtra is concerned, now there are the teams which are formed. So henceforth, for forensic evidence only, there cannot be any acquittal. So this is important. So far as 176(3) is concerned, believe I'll request Honorable Principal Ma'am and all that kindly summon somebody or kindly call some forensic expert in your college and have his lecture. So our student will be equipped with forensic knowledge also. So this is important. Now we are entering in some different regime. Knocking the door of court, that is first information report. Now people say FIR, somebody say FRI, somebody and all. But first information report, which was there in section 154, now has some different glimpses or different facets in section 173. Now FIR, which used to be there in the regime of CRPC, which used to be lodged before the Thane Amallar of any police station. We used to go to police station. Thane Amallar used to tell us that no, sit there for 1 hour, our PI is to come. And somebody used to say that no, wait for some time. Somebody used to say that no, not this police station, that police station. Not Povainaka police station, but Rajwada police station. At Rajwada police station, somebody used to say that no, this is not in Arka. You have to go to Nakthane police station. Nakthane used to say that no, that river is not in our jurisdiction. You go to Umbraj police station because dead body is found at Umbraj. So in Umbraj, people used to say that no, that is not in our jurisdiction. Ultimately, clothes were found at Karad police station. So he used to run from Satara to Karad, passing all throughout. But now that will not be the scene. Now FIR can be lodged from any place to any police station, and that can even be lodged by using electronic communication. Now this is the proactive role that has been taken care of by the BNSS. Now it does say, now it has articulated two important things, that there will be EFIR. There can be EFIR. EFIR can be there, as well as there can be zero FIR. Now these two concepts we must know. Now it has given now FIR, say for example, offense has been committed in Karad, and person who is about to lodge FIR is sitting in Satara, whether he can go to Satara police station. Earlier there used to be like non-inclination saying that no, the offense has been committed at Karad, go to Karad police station. Don't lodge it at Satara police station. Now that will not be the scene. Now person can go to Satara police station, Satara city police station, saying that sir, I have to lodge FIR over here only. And you have to pass it on to Satara, Karad police station, the jurisdictional police station. So it says police station, FIR can now be lodged in any police station irrespective of the area where offense is committed. We'll stretch the situation. Now offense is committed at Karad and FIR is lodged at Bangalore. Whether that can be done? Yes, it can be done. Now offense is committed at Karad. FIR is required to be lodged at Mussoorie police station. That can be done. So now we are a kind of global village, and FIR can be lodged at any place. And this is important. So in BNSS, FIR can be lodged in any police station irrespective of the area where offense is committed. So zero FIR and that non-inclination to take down FIR is no more the scene of the day. Now it can be lodged at any place. So this is going to be an important provision so far as lodging of FIR is concerned. This is a novel concept, So this is important. It has given validity to zero FIR. Now going to police station and lodging FIR is another aspect. Now zero FIR means police FIR can be lodged at police station which is not having jurisdiction. Now that can be done. Now another facet is EFIR. Now FIR can be lodged orally. Now go to police station, go to any police station and lodge FIR. That can be done orally. Now taking down signature on FIR register, giving copy to the informant and all, that is bound to be there. But now FIR can be lodged by way of electronic communication. Believe me, this is going to be the greatest thing. Now at some because you must be knowing that at some place some EFIR was lodged by somebody against some political leader. Now that is going on in some place, present day situation. But EFIR EFIR can be now lodged. Now I need not go to police station. I am sitting in my office. I came to know that water pump which was inducted in my society has been stolen away. It was worth rupees 20,000. Now I can send mail to concerned police station saying that, sir, this is my FIR, take it down, start with the investigation. That can be done. Now this is going to be the, I mean, because a person need not go to police station. In our system, we call it as a nyaya apल्या दारी. So even courts are coming to your court, your doorstep. Why not police station? So this is the philosophy, because we are the, we have to do good governance. So ultimately the person can lodge FIR by sitting in his own office, own house, own premises without going to police station. So it can lodge FIR. Now there is bit qualification so far as EFIR is concerned. Now if FIR is lodged by electronic communication, say for example, I lodged FIR by way of sending my email. By sending email, I have lodged FIR. Now what is to be done? Now if I have lodged FIR, then I'll be required to go to police station within 3 days and make signature on physical FIR. So from the date of lodging of EFIR, I'll be required to go to police station within 3 days and sign on FIR. So that can conveniently be done. There should be no hitch for it, or nobody should have any question mark for that, why I'm required to go. But within 3 days, he'll have to go to a police station, but immediate FIR is important concept. See, for example, earlier there used to be cross-examination on the point of belated FIR, that they used to say, now your place or the place of the residence of informant who lodged FIR is at a distance of 10 kilometers from police station. Why you didn't lodge an immediate FIR? So the time required is 10 minutes, time required is 1 hour, 2 hours. Why you didn't lodge FIR in 2 days? Why you didn't lodge FIR in 1 day? Now those defenses are no more defense. Only defense is that whether you were having mobile phone with you. Now, if you had mobile phone with you, why you didn't lodge FIR immediately by using electronic communication? Because mobile phone is audio video electronic means. And by sending it by your email, you can send it to the police station. Why you didn't lodge FIR immediately? So prompt FIR is going to be the result of the day by using EFIR under new provisions of BNSS. So this is kind of like a revolution, and its cognizance is going to be taken by our system, by our BNSS. So this is the classic nice example of our new legislation. Now, the cognizance is also taken by the legislatures of some mischief. Now, persons used to lodge FIR rampantly in respect of cognizable offense, and after conducting inquiry, there used to be output like, no, there is nothing. So, particularly in respect of offenses which are punishable, above 3 years and below 7 years. So 3 to 7 years punishments slot offenses. Now offense is punishable above 3 years and less than 7 years. Now if there is false implication and false FIRs, because once FIR is registered, no option remains but to send either 169 report or to send charge sheet. But now that will not be there. Now there will be preliminary inquiry done by the police. All we are aware about the case law of Lalita Kumari's case. All we legal persons are knowing the Lalita Kumari's case on the point of registration of FIR, because it is mandatory on the part of police to take down FIR if the offense is cognizable. But that is given some qualification. So Lalita Kumari's case is given, rightly taken cognizance and given qualification by way of preliminary inquiry while taking down FIR. It does say that offenses which are punishable with imprisonment for 3 years or more, but with imprisonment less than 7 years. So 3 years above offenses, 7 years below offenses. Now 3 to 7, the offenses falling in these categories for in respect of punishment, there cannot be direct FIR. Now there has to be some PE. PE means preliminary inquiry. There has to be some preliminary inquiry. Now that will be done by officer in charge of police station. And if during that preliminary inquiry, officer in charge of police station comes to know that yes, there is prima facie case to proceed against, then there will be further investigation done. Now this is the salutary provision, the best the best provision incorporated in BNSS. Now it does say that officer in charge of police station with the prior permission of officer not below the rank of DYSP, so he is required to conduct the preliminary inquiry. Now that will be that preliminary inquiry in respect of cognizable offence for which punishment is less than 7 years and above 3 years, that can be inquired or that can be taken for inquiry by the officer in charge of police station. And for that purpose, prior assent of the device is required. So this is important aspect. Now, what should be considered in this preliminary inquiry? So the officer in charge of police station should consider the nature and gravity of the offence, as to whether the offence is grave, what is the nature of offence, and after inquiry of these things only, further investigation will be conducted, or the investigation will be ensued rather. So this is important so far as PE is concerned, preliminary inquiry is concerned. And what is the purpose of PE? That whether there is material to proceed in the matter. Because somebody may say that, sir, XYZ offence has been committed, but upon perusal of FIR, there doesn't seem apparently anything so far as that commission of offence is concerned. So let that officer in charge of police station commit some kind of inquiry and infer and draw certain inference. So that will be required. So that will be purpose of preliminary inquiry. What purpose? See, because preliminary inquiry is not the investigation. I hope inquiry and investigation terms are properly defined and understood. So that those were defined in CRPC and those are continued in BNSS also. So that this will not be investigation kind of thing. This will be inquiry. And why that inquiry will be conducted at the end of officer in charge of police station? Merely to see whether there is sufficient material to proceed in the matter. And if there is sufficient material to proceed in the matter, then further investigation shall be done and to ascertain the prima facie case. So this is important aspect so far as PE is concerned. Now that PE should be conducted within 14 days. And so now the victim-centric approach is also done, is also been taken care of in BNSS. It does say that copy of FIR is also required to be given to victim. See, because in earlier days in CRPC regime, copy of FIR was never given to the victim. The term victim has been used. It used to be given to the informant, rather the person who set law into motion. Now under 173(2), it does say that as per section 154(2), copy of FIR was required to be given to the informant. We know that in CRPC regime. But now in 173(2), that is new provision of BNSS, which is pari materia to earlier 154(2), copy of FIR is required to be given to the informant or victim. Victim is also been given the copy. Now, in case of non-cognizable offence, all we know that under section 155, there cannot be any investigation unless that has been permitted by the magistrate. So, if non-cognizable offence is registered at police station, what is its fate? Unless we go in private complaint before the magistrate, there cannot be any there cannot be any redress. So, and non-cognizable, say for example, there used to be thing that people used to go to police station informing cognizable offence, and police, say for example, used to say that no, this is not cognizable offence, this is non-cognizable offence. They used to register it as NC case, non-cognizable case, and give copy thereof to the informant, and they used to direct him to the police, direct him to the court. Now that person may come to the court, may not come to the court. There was no check of court. Now there was no moderation, there was no monitoring by the court. Now that kind of pseudo monitoring is there in case of non-cognizable offence. Now it does say that in non-cognizable cases, the courts are, the police stations are required to maintain daily diary report. Now, how many non-cognizable cases are received by police station will be watched by the magistrate. And this is, pseudo monitoring kind of thing. This is important because it does say that officer in charge of police station, after taking down non-cognizable cases, refer the complainant to the magistrate, and for 15 days, every 15 days after, it is called as daily diary report, but it has to be forwarded fortnightly to the magistrate. Now, after every 15 days, the magistrate will receive daily diary report as to in these 15 days we received these 105 cases. In these 15 days we received 100 cases. In these 15 days, 15 days. In these 15 days we received 10 cases of non-cognizable cases. Meaning thereby the copy of non-cognizable case, I mean the report of registering non-cognizable cases will be required to be submitted to the magistrate. And magistrate will have some kind of appraisal of the situation as to how many non-cognizable cases have been registered by police. So this is important aspect. In case of cognizable offences, as we know that SP, Superintendent of Police or DYSP, never used to investigate into the matter, except some few cases like Atrocity Act cases and all. Some special laws are there. But generally, Superintendent of Police never used to investigate into the matter. Now, it does say, considering the nature and gravity of the offence. Now, BNSS mandates that if offence is grave or offence is of a such nature that it requires some kind of expert investigation or superior officer investigation, even Superintendent of Police may investigate into the matter of the offence himself, or Superintendent of Police, SP, may require DYSP to investigate into the matter. So these two important officers now can investigate into the matter, looking at the nature and gravity of the offence. So this is important. So this is 175(1) provision that has been done in BNSS. So this is also quite novel provision and most important provision incorporated in BNSS. Now, all we people know 156(3) matters, 156(3) matters, that is the directions which is required to be given to the police station by the magistrate to register the offence and investigate into it. Now, say for example, private complaint is filed or an application is made to the magistrate in respect of cognizable offence. Now, magistrate is of the considered opinion that no, some investigation is required at the end of police station. So it can direct the magistrate to investigate into the matter under section 156(3) in CRPC regime. Now, that can now how that modality is been taken care of in BNSS, let us see. Now it does say magistrate will be required while giving direction to about the investigation under section 156(3), new 175(3), that magistrate will consider the application or supporting affidavit. Magistrate should make necessary inquiry as he thinks fit, and magistrate should give audience to the police. This is important. Why? Because person, while claiming investigation under 156(3), used to say that, sir, I had gone to police station, but police didn't take down my FIR. Now that was something qualified in Priyanka Srivastav case. All we know. So Priyanka Srivastav case used to say that you'll have to file an affidavit, you'll have to file copy of 154(3) compliance and all. But now magistrate, before directing investigation under section 175(3), 173(4), 175(3), 156(3). So magistrate, before giving direction under section 156(3) CRPC, earlier I am talking of. So magistrate, before directing an investigation at the end of police station, is required to consider the submissions made by the police officer. Now, earlier there was no audience given to police. Now the complainants used to tell the magistrate, now sir, I had gone to police station, but police is not taking down my FIR. And there was really no kind of counter check. Now magistrate will be calling that submissions of police officer, and thereafter appropriate this thing used to be done. Now this is important. Now if at all 156(3) is to be done against police, against the public servants, in Maharashtra there was provision about, earlier in CRPC regime there was provision about taking down sanction or taking sanction from the senior officer of the accused. Now under BNSS, if private complaint is, or if direction of investigation is to be sought against public servant in respect of the act done by him in discharge of his lawful duty, what is required to be done is that upon receiving a complaint against public servant in respect of an act, magistrate will call report from the superior officer. See, your junior, there is complaint against your junior officer. Now superior officer will furnish his report as to what happened. Similarly, an accused, rather the person who is projected accused projected as an accused will also be heard by the magistrate. And this is the, this is the magical thing. And this is very important thing. See, because now the report will be called from the concerned senior officer, and report will also be called, or assertions will also be called from the public servant who is projected as an accused. So the magistrate will have some clear-cut kind of idea as to what has happened. And thereafter, there can be direction of investigation made under 175(3) or earlier 156(3). See, because everything is expected to be done in fair manner. Somebody going to come magistrate and saying that, no, sir, my police station is not taking my FIR, or police station is not taking down my report. So direct an investigation under 156(3) now will not be the scene. Now, what will be required to be done? Even if you are saying that, yes, I had gone to police station, but police station did not take my cognizance or did not take down my FIR, magistrate will conduct inquiry first. Magistrate will call the report of that superior officer of the public servant, and magistrate will call assertions, or magistrate will call explanation of that public servant who is projected as an accused. See, because seeking investigation against a public servant, it's something serious. It is something drastic, because that public servant, apart from getting mentally disturbed, his work is always hampered. Because the act which is projected as an offense in 156(3) is always the act which he is doing in the discharge of his official duty. Now, for doing my official duty, if I am going to be investigated into by police, I am bound to be disturbed. So in that matter, right provision has been done by the legislature. It does say that call the explanation of that accused, projected accused, call the assertion of that public servant, and thereafter you decide the things. So this is important thing that we are required to take care of. Now there is victim focused investigation. Now, if at all police is deciding that, no, I'll not investigate into the matter, or I'll not go to the police, I will not go to the spot, then in that matter, that victim is required to be given an intimation that that investigating officer will have to tell to that victim that even if you have lodged FIR, I will not visit the spot, or I will not investigate into the matter. So this is novel provision. This is victim focused investigation is done. So kindly read that 176(2). One more, that non-investigation daily diary, like 155 daily diary is there. Then there is one more thing, recording of, now see, if at all if a magistrate is, now this is 183 means earlier 164 statement which were there, which used to be taken by magistrates, recorded by the magistrate under section 164 are now under 183. Now, if at all, if offense is punishable with women atrocities, particularly under section, earlier sections, I'll tell you 354, 376, POCSO and all, women atrocities, then in that matter, that evidence is required, that statement is required to be recorded by the magistrate who is a women magistrate or lady magistrate. So gent magistrate having some embarrassing position for that victim will not be the scene. Henceforth, that will be recorded by the women magistrate. And if woman magistrate is not there, male magistrate can record the statement of that victim. So this is a conducive environment created for the administration of justice so far as women atrocities are concerned. Now, recording statement of disabled person. Now, disabled person's statement can be recorded by mobile phone. Now, this is also the salutary feature which is done. Now, search which is required to be done by the police officers are preferably recorded by mobile phone, that we have seen. Now, this is also important aspect. This is not much important. Now, remand. Now, earlier there was 167 remand, police custody and magistrate custody. Now that section is substituted by new 187. Now that 15 days rider is not there, but that is subject matter of interpretation. I'll not comment on that right now, because the section which has been legislated, or section which is in literal sense 187(2), substituting 167, is having some different facets. Now the term which was earlier there in 167, the term used in earlier 167(2), 167 was that not custody, not that of the police custody. Custody other than police custody is the missing term in 187. So the interpretation is, yet before the honorable superior courts. But you appreciate this section as it is. So I'll not comment on this because that is having some different facets. So I'll refrain from that. Now, one more thing, one important thing has been done is that POCSO cases are required to be investigated within 2 months. So 4, 6, 8, 10. Actually, there is provision in POCSO Act also, but now that has been incorporated in BNSS also. It does say that yes, POCSO cases are required to be investigated in 2 months. So that is, timelines are there. Now, as we had seen that there can be EFIR, there can be e-summons, but there can be electronic charge sheet also. Can we imagine this thing? Now the charge sheet or the end result of the investigation is charge sheet, as we know that earlier there used to be charge sheet under section 173(2). Now there will be 193(3). Now there is reshuffling of sections only. But charge sheet is, I mean, we can see the charge sheet now in electronic form also. This is important. So electronic charge sheet is also going to be lodged. It does say that as soon as investigation is completed, officer in charge of police station shall forward, including through electronic communication. So now see, the physical charge sheet has not been dispensed with. Now the charge sheet or the paper charge sheet or physical charge sheet, which we are seeing or which we are witnessing in daily courts, that has not been dispensed with. Now the electronic charge sheet will be additionally filed. Now I am optimistic that subsequently the day will come that only on electronic charge sheet will be required to go on. So this is also going to be happen. Now while submitting this electronic charge sheet, the police machinery is required to give chain of custody or sequence of custody in case of electronic device. See, for example, now this is the electronic device which has been seized during investigation. Now that has been seized by accused, seized from the accused by PSI XYZ. Now PSI XYZ has given it to the Thana Mohrir, or we may say officer in charge of police station. Now officer in charge of police station has given it to property room. Property room has given it to the forensic science laboratory. Forensic science laboratory has sent it back to the officer in charge police station. And officer in charge of police station has given it to the investigating officer, and IO has sent it to the court. Now this electronic device has changed 10 hands in between. From accused, officer in charge, investigating officer, officer in charge, Thana Mohrir, Muddemal clerk, carrier police, again to forensic science, thereafter forensic science to again investigating officer, and now to the court clerk. Now these are the 9 to 10 hands which are changed so far as this electronic device is concerned, or electronic communication, electronic article is concerned. Now, in respect of this changing of hands, at every hand there is possibility of tampering with some electronic data. To avoid the mischief or to settle the liability, now this BNSS says that for that purpose, the charge sheet should project as to the sequence of custody. First of all, who seized, later on, who take it in custody, later on, who took it, later on, who carried it, later on, who opened it, later on, who sealed it, and later on, who took it on court record. Now that sequence of custody is required to be mentioned in case of electronic record or electronic device. Why? Because we have to see whether there was possibility of tampering, and if there is tampering, who was responsible for it. So this is also important aspect which we are required to take into consideration in case of electronic charge sheet. But as I have already said, that due to electronic charge sheet, our physical charge sheet is not been dispensed with. That we have to appreciate. Again, I know that we are running short of time, so I am a bit fast. Information in respect of investigation is required to be given to the police, is required to be given to the victim also. So victim should know as to what is the stage of my investigation. This is important aspect. One more thing, supply of documents to the accused. Now documents are required to be supplied by way of electronic communication. Even the documents which are given to the accused by way of electronic communication are also the valid documents. That is important. Now further investigation which was there under 173(8) of CRPC, now it will require the permission of the trial court, and that has to be completed within 90 days, max to max 180 days. This is novel provision that has been done in CRPC, BNSS, I'll say. AD cases, which we know that inquiry of AD cases under 174(2) is now made time bound. Now there are various time slots which have been there. Now this is not important. Now last part which I'll be delving upon is as to the cognizance of offense. So if cognizance of offense is to be taken, then accused is required to be heard. So notice is required to be given to the accused as to why you should not be proceeded against, why cognizance should not be taken against you. Earlier we used to lodge FIR in the file complaint in the court case, and there used to be examination after institution of the complaint. There used to be examination under section 200. Thereafter, if possible, further investigation or inquiry under 202, and thereafter there used to be issue process. Till issuance of process in CRPC, there used to be never any audacity given to the accused. Accused had no voice to state. Accused had no role to play in the complaint cases. But now there can be now the accused is required to be heard. It does say upon receiving a complaint of facts, including complaint filed by a person authorized under any law, and upon this thing, there can be the accused is required to be heard. So that is important. This is what section 223 does say. It says no cognizance of an offence shall be taken by the magistrate without giving an opportunity of being heard. See, this provision was not there. This provision was not there in CRPC. Accused was never required to be heard. So this is important, and this provision has been newly incorporated in BNSS. Now, if at all complaint is to be filed, private complaint I am saying, if at all private complaint is to be lodged against a public servant, then that public servant is also required to be heard, and his superior officer's report is required to be called. Now, this is the novel provision, because unnecessarily dragging public servants into private litigation is required to be stopped at some point of time, and its cognizance is rightly been taken by the new code or the new Sanhita BNSS. So this is important. Again, one more thing, issuance of process. Now summons and warrants can be issued by electronic means, that we know. This is important. Supply of documents to the accused. Now, if at all documents are to be supplied to the accused, that has to be without delay under section 207 CRPC. But now that has to be done within 14 days from the production of accused or appearance of the accused. Now, there used to be stages. The trials used to get derailed by saying that documents are to be supplied. Now, documents are required to be supplied in time frame manner within 14 days from the date of production. So no more delay will be entertained on that premise. Supply of documents can now also be required to be done to victim. Now see, this is the novel change which has been brought on record. Earlier in CRPC, documents were never given to the victim. Victim had to file an application for certified copies in the court, and thereafter he used to get it at his own cost. But now, if he's if that victim is represented by an advocate, then copies are given to him free of cost. Then that is important. So victim-oriented philosophy or victim-oriented procedure has been adopted in new law. This is also important. That documents can be supplied by electronic form is also the novel provision which is done in the new law. Supply of documents, this is not much important. Now cases will be required to be committed within 90 days from the date of filing of cognizance. Now, magistrate taking cognizance cannot derail or cannot delay committal of cases, because there used to be very many cases which are pending before the magistrate. So those cases which were pending before the magistrate for committal will now be curtailed, because within 90 days or max to max within 180 days, those cases were required to be committed. Now, session trial, there are certain discharge application will be required to be filed within 60 days. Now, these are the time slots. Now, charge will be required to be framed within 60 days. Again, charge can be explained to the accused by using audio, video, electronic means. This is the novel provision. Evidence by audio, video, electronic means is also been allowed. Now the judgment, now for passing the judgment, there is timeline given that within 30 days after completion of arguments, you will have to pass the judgments, and it can be extended up to maximum 45 days. So judgment is required to be delivered within 45 days only. So this is the new thing which has been brought on record. Now for warrant trial on police report, no much change. One thing which I want to imbibe upon you is that, yes. Now in summons cases, earlier there was never an application for discharge. Because in summons cases and in summary cases, as we all know, no formal charge is required to be framed. Now, in that, there used to be, I mean, like discharge. If at all there is some discharge application filed in summons case or summary cases, there was no provision in CRPC, which provision is now been made in BNSS. It does say that if the accusations are totally groundless, then there can be application for release of the accused. It doesn't say discharge, but it does say that there can be release of the accused because formal this thing is not required. So admission of document 294, that is made time bound. That has to be done within 30 days. Admission of documents by expert. For that purpose, expert need not be called in the court. This is something new thing which has been brought into effect. Now, curtailing adjournment, as has been always been, we are blamed for that there are casual adjournments. Now, BNSS says that there can be only 2 adjournments granted in the court. So let us see how we can implement it. So this is one of the steps taken by the legislation for expeditious disposal of cases and administration of justice. It does say that only 2 adjournments can be granted, and that too, for that purpose, court or magistrate will be required to give reasons for that. So this is also important provision that has been done. Again, this is the last portion. Inquiry, trial, or judgment in absence of accused can now be done. And one more thing, if at all prosecution is to be withdrawn, now this is the novel provision that has been made. If at all prosecution is to be withdrawn, then opportunity of being heard is required to be given to the victim, and this is important. So POCSO cases are required to be tried in camera matter. I mean, without there being anybody in the court except the advocates and the victim and the judge, of course. So now anticipatory bail, in case of anticipatory bail, now the riders are changed. Now this red color matter which has been flashed was there in CRPC, which will not be there, and rather that has been deleted from new 482 section 482 of the BNSS, that has been deleted. So, and one more thing, in anticipatory bail there will be no provision regarding interim protection has been omitted, but by virtue of one case law of the Honorable High Court of Bombay bench at Goa, now there can be interim protection granted. So now disposal of property. Now property is used to be there in the court, languishing for months together, years together, I'll say. But now the court will snap the photograph of property which is produced before it, and immediately dispose it of. So that provision is already there. So disposal of property is new provision under section 497 to 505 of BNSS. So this is there. So disposal of property has been expedited. And last section is trial and proceeding in electronic mode. Now see, by articulation of electronic communication and by introducing audio video electronic means in the administration of justice, legal recognition is given to certain facts. Now what is that? That what court can do with electronic gadgets or with electronic mode, audio video electronic means, is that issuance of summons, issuance, service, execution of summons and warrants, holding inquiry, examination of complaint and witnesses, trial and plea bargaining, recording evidence, trial before High Court, appeal proceedings. Now this all can be done by the electronic thing. Now this all pertains to the new law which is there so far as new laws are concerned. Now so far as BNS is concerned, there is no much change that we can, some mob lynching procedure is there that you can read. One terrorist act is the new provision which has been incorporated, which is also salutary provision. And organized crime, which is pari materia to Maharashtra Control of Organized Crimes Act, is also incorporated in BNS. And so far as Evidence Act is concerned, the scope of primary evidence and scope of secondary evidence has been enlarged. I'll request, if we can arrange for Indian Evidence Act on the point of document proof admissibility. There is a whole entire legal scenario has now been changed. Now it does say that document is audio, electronic and digital record is also incorporated in document, and accordingly provisions of primary evidence and secondary evidence in the Indian Evidence Act, newly Bharatiya Sakshya Adhiniyam, are incorporated. So the scope of primary evidence and secondary evidence is now enlarged so far as BSA Bharatiya Sakshya Adhiniyam is concerned. So I tried my level best to complete all the things. but there are very many things which are left out, but owing to the paucity of time, I stop myself. And if anybody is having any query, then we can discuss it. And I first, last but not least, I must thank the Honorable Management Committee, Honorable Principal Jadhav Madam, and Honorable Coordinators for giving me an opportunity and availing this platform for me to have some sharing of thoughts with you people. Of course, whatever I have shared is by way of literal interpretation, which I could get from the new laws. I can understand that there can be different perception, different. So these are my glimpses so far as new laws are concerned. Actually, there are very many things which can be discussed, deliberated, and interpreted. So thank you very much. If anybody is having any query or any point to discuss, we can go on. Thank you.
Participants can ask their questions. Participants are hereby requested that only if they have their doubts, please on your microphones, else switch off your microphones.
One thing I like to suggest that even if questions, if they are comfortable, they can ask it in Marathi. मराठीत कोणाला प्रश्न विचारायचे असतील तरी सांगा, आपण मराठीत चर्चा करू, तसं काही प्रॉब्लेम नाही. किंवा जर काही एखादी कन्सेप्ट मराठीमध्ये जर हवी असेल तर आपण मराठीत सांगू, और किंवा शंका जरी मराठीत विचारली तरी चालेल, काही प्रॉब्लेम नाही. थँक्यू.
You explained it so aptly, sir, that I really don't feel participants might be having any doubts.
Yes, thank you.
It was really a wonderful session, sir. You rightly highlighted the practical nuances of the three new laws, namely Bharatiya Nyaya Sanhita, Bharatiya Nagari Suraksha Sanhita, and Bharatiya Sakshi Adhiniyam. It helped us get a deeper understanding of the changed facets of criminal jurisprudence. Thank you, sir.
Thank you very much.
Anybody still having any doubt? Please kindly ask.
Hello, am I audible?
Yes.
Yes, Ujjwal, please.
सर सेक्शन 107 107 मध्ये क्राईम प्रोसिड्स बद्दल थोडं काय विषय?
क्राईम प्रोसीड ही अशी एक कन्सेप्ट आहे. जर तुम्ही आपण कधी समजा मी एक चोर आहे किंवा मी समजा एखादं मिसअप्रोप्रिएशन केलं, एक सोसायटी आहे, त्या सोसायटीमध्ये मी क्लर्क आहे आणि मी काय केलं तर त्यांचे पैसे गोळा केले आणि पैसे गोळा एखाद्या 10 लोकांकडून मी ते पैसे गोळा केले आणि मी त्याचं डिफॉल्केशन केलं, मिसअप्रोप्रिएशन केलं. मी किती पैसे घेतले त्यांच्याकडून? प्रत्येकाकडून 4 लाख घेतले आणि 40 लाख रुपयामध्ये मी एक जागा खरेदी केली. 10 लोकांकडून पैसे गोळा केले, त्याच्याकडून 10 लोकांकडून 40 लाख रुपये घेतले आणि ती जागा खरेदी केली. आता ती जागा माझीच आहे, परंतु ते 40 लाख रुपये आले कुठून? तर जो काही क्राईम केला तर त्या क्राईम मधून मला मिळालेले जे पैसे आहेत, दॅट इज द क्राईम प्रोसिड्स. आता ते क्राईम प्रोसिड्स BNSS असं म्हणतं की ते क्राईम प्रोसिड जी आहे ती जागा जप्त करा, जागा विकून टाका. त्यामध्ये कलेक्टर आणि मॅजिस्ट्रेट ह्या दोघांचं जॉईंट व्हेंचर असणार आहे ते. आणि त्याच्यानंतर मग ती जागा विकून जे पैसे मिळतील ते क्राईम प्रोसिड्स, ते जे कोणी अफेक्टेड पर्सन्स आहेत क्राईमनी, त्यांना देऊन टाका. तर इतकं सिंपल आहे. म्हणजे गुन्ह्यातून मी जे काही कमवेन ते ज्यांच्या विरुद्ध गुन्हा केलाय त्यांना परत देऊन टाकायचे. दॅट इज द क्राईम प्रोसिड्स. 107 सेक्शन मध्ये त्याची डिटेल प्रोव्हिजन आहे. हालाकी दॅट इज पॅरिमट. त्याचीच एक ग्लिम्स जर तुम्ही कधी मोका कायदा वाचला असेल तर मोका कायद्यात पण अशाच प्रोव्हिजन आहेत. ठीक आहे, पण मोकाच्या अगदी डिटेलमध्ये न जाता आता त्यांनी 107 सेक्शन मध्ये सगळ्या कायद्यांना हे केलेलं आहे. मी चोर आहे, मी 10 मोबाईल चोरले 10 लोकांचे आणि ते विकून टाकले आणि मी 10,000 कमावले, मग प्रत्येकाला 1,000 रुपये देऊन टाका, रेटेबल डिस्ट्रीब्युशन करा, असं ते 107 सेक्शन म्हणतात.
सर क्राईम प्रोसेस डिस्पोज ऑफ कधी करायचं? म्हणजे प्री ट्रायल मध्ये येतं की आफ्टर ट्रायल?
यामध्ये ट्रायलचा रायडर कुठंच नाहीये. BNSS ची जर 107 बघितलं तर ते कुठंच असं म्हणत नाही की ट्रायल होईपर्यंत तुम्ही क्राईम प्रोसेस डिस्पोज ऑफ करू नका, परंतु प्री ट्रायलही करता येतं आणि ते आपल्याला ते डिस्पोज ऑफ करता येतं. अर्थात यामध्ये मेन इंटरव्हेन्शन जे असणार आहे तर ते मॅजिस्ट्रेटचं आणि कलेक्टरचं असणार आहे. स्टेजचा बॅरियर नाही त्यामध्ये कुठेही.
ओके सर, थँक्यू.
ओके. अजून कोणाला काही शंका आहेत? Yes, madam.
ज्या पार्टिसिपंट्सनी हँड रेज केलेले आहेत त्यांनी प्लीज आपले क्वेश्चन्स विचारू शकता. Okay, I feel there are no more further doubts.
Thank you.
We will proceed towards the vote of thanks session. I would now like to request IQAC coordinator, Professor Desai sir, to kindly propose the vote of thanks for today's webinar.
Hello, am I audible?
Yes, sir, you're audible.
Thank you, Aditi. Really, this is very good session, sir. We have get very much insights about the Bharatiya Nagari Suraksha Sanhita. I know the time is very short, and it is not possible to cover all these three subjects within this short period. But still, you have in detail discussed about the Bharatiya Nagari Suraksha Sanhita. You have given insights about the basic and important provisions of this act. It will definitely help the students in their coming futures to become a good criminal lawyer. And for this, I would like to give special thanks and appreciation for your presentation, sir.
Thank you.
Received your presentations regarding three subjects, and with your permission, we will definitely circulate these presentations with the students also.
Yes, sir.
These presentations will definitely give insight to the students about these laws, and definitely it will helpful to the student in their examination as well as in their academic career also, sir. So you have given a valuable time for us, and you have, despite of your busy schedule, you have spared the time and given the lecture on the topics of Bharatiya Nagari Suraksha Sanhita. So on behalf of the students as well as on behalf of the college, I would like to give thanks to you. Thank you very much, sir. Your speech, your presentation, as well as your knowledge is really appreciable. So it will definitely, we need your support in even coming futures also, sir. Definitely, we will organize one of the program in offline mode so that student can get more knowledge about these subjects. So thank you very much, sir. You have given very wonderful presentation. Thank you very much. I also like to give special thanks to our principal ma'am, Dr. Vaishali Zadav, for organizing this kind of session and giving knowledgeable inputs to the students. I also like to extend my thanks to our lead college coordinator, Mr. Praveen Zadav sir, for organizing this lead college activity, all the teaching, non-teaching staff of this college, as well as all the participants from different colleges throughout the Shivaji University, and the student participants from the Ismailsaheb college for being patient hearing. So thank you all. This session is really wonderful, and this will definitely enlighten us with our knowledge. So thank you well and all. With the kind permission of the today's guest, I will declare that this session is being concluded. Thank you very much.
Thank you very much, sir. Thank you.